Ready? Hello, Mr. or Mrs. Chief Justice. May it please the court. My name is Shreya Jt, and I'm here on behalf of my co-counsel, Shreya Venkatachalam. And today we'll be representing the petitioner side of New York State Rifle and Pistol Association.
So, Your Honor, for a brief overview of this case, on September 2014, two men in New York, Robert Nash and Brendan Koch, applied for a concealed carry license. Both were, however, denied those licenses, despite the fact that Nash was motivated to carry it because of the recent robberies in his neighborhood. He had participated in a gun training course, and Brendan Koch is highly well-versed in firearm practice. Neither had a criminal history. However, both of them were denied their Second Amendment right to a firearm.
What does the Second Amendment protect?
Your Honor, the Second Amendment essentially protects the right to keep and bear arms, meaning the right to not only have firearms in your possession, but also to carry or wear it. It protects the entitlement of the people to be able to protect themselves in self-defense.
So for the summary of the argument, we said the Second Amendment in the United States Bill of Rights speaks for one of the founding fathers' most valued rights to undo the wrongdoings they faced. It also stands for the safety and protection of the people, the very people that the government is made of, by, and for.
It protects the right to keep, which dictionaries define as retaining possession of, as well as bear arms, which is defined as the wearing or displaying of said carried firearms.
So the framers of the Constitution, the very foundation to our nation today, wrote a highly passionate and daring Declaration of Independence containing 27 grievances, each carefully and purposefully phrased to get the sheer injustice of their situation across. A few years later, James Madison wrote the Bill of Rights, inspired by documents such as the Declaration of Independence, Magna Carta, and the English Bill of Rights, to establish the basic rights they were denied at the time of the founding fathers.
Why did the framers include the Second Amendment? Why did the framers include the Second Amendment in the Bill of Rights?
The framers included the Second Amendment in the Bill of Rights in order to grant individuals the right to carry firearms and protect oneself against standing armies. For example, Alexander Hamilton asserted that a well-regulated militia is the most natural defense of a free country. The founders agreed that a well-regulated militia was needed to protect against any standing armies. One essential reason the founders established the right to bear arms is to prevent the United States from starting an army in order to protect the security of a free state. Placing the right to bear arms as the very Second Amendment demonstrated its high value and established the right for Americans to be able to actively defend themselves and even just possess firearms.
So under the English, after facing much abuse and injustice, the amendments were written intentionally to constitutionalize the carrying of firearms. 20th and 21st century sources, as well as case laws, support the right, not privilege, right of citizens to carry guns for protection.
The text of the Second Amendment, as well as the 14th Amendment, protects the right to have and carry firearms. To begin with, let's define keep and bear as mentioned in the Second Amendment.
What is the difference, if any, between the verbs keep and bear?
So, Your Honor, as mentioned before, keeping a gun is just in general having one in your possession. It doesn't necessarily need to be on you to be kept. Bearing a gun, on the other hand, is actually carrying it. The Second Amendment mentions the right of the people, the word right being specifically used. Oxford Languages defines this term as a moral or legal entitlement, a fundamentally basic protection that in terms of the Second Amendment, the people of America need, deserve, and should have. Furthermore, Your Honor, the Second Amendment mentions the right to keep and bear firearms. Modern dictionaries help define these words and give more clarity despite there having been minimal to no change in the definition over the years. They define keep as the ability to have something in one's control or in one's possession, while bear refers to carrying or wearing, and in terms of this amendment, the possession of arms. As a whole, the second half of the Second Amendment protects the right to have a firearm and carry it if needed for self-defense.
What are the limits of the Second Amendment's protection?
Of course, there are limitations. The framers were constantly looking forward to that when they were drafting the Constitution. In 2008, the US Supreme Court ruled that the Second Amendment protects the usage of guns for legal purposes and self-defense. The outcome of Heller explained, the Second Amendment right is not unlimited. It is not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose. Federal law covers the limitation of legalizing dangerous and unusual weapons, such as semi-atomic weapons, but most of it boils down to state regulations. Federal law also prohibits certain people from carrying firearms, such as those who are convicted felons or under restraining orders, people labeled mentally ill by the court, drug abusers, and even undocumented immigrants. There are also limitations on places a gun can be taken, such as not in schools, government buildings, airports, and even polling systems. Moving on to the second part, Supreme Court interpretation of free state and militia. So the literal text of documents, such as a constitution, are highly useful and priceless, and the interpretation of words written hundreds of years ago by America's founding fathers.
So you have explained keep and bear. What is a militia and why did the framers refer to it in the Second Amendment?
That's a great question, Your Honor. The constitutional definition of a militia is the military force of the nation that consists of citizens chosen to suppress mutiny and obstruct invasion from occurring. The framers refer to a militia as being the very reason why citizens have the right to keep and bear arms. Therefore, the framers concluded that an organized militia was necessary to protect the country against political instability, and that every man deserves the right to be armed in order to participate in the service of the militia or even in general for self-defense. D.C. v. Heller acted as the Supreme Court case that finally gave insight on the interpretation of these words. The court rulings by Justice Scalia declare that a militia is not restricted to just members in the military. At the drafting of the Bill of Rights, people who were eligible for serving in the military were mostly able-bodied men, and when the colonists faced their abuse and took up their guns to retaliate for freedom, nuances such as them having to be men professionally in the military weren't important. Any person in need of protection or self-defense is guaranteed to be able to have and carry a gun. Essentially, Madison supported the idea of liberty, claiming that the ultimate authority, wherever the derivative may be found, resides in the people alone, which is why Madison felt that an efficient militia is necessary to be included in the Second Amendment. In addition, Richard Henry Lee claims that a militia, when properly formed, is in fact of the people themselves. According to the past and general usage of the states, Lee states that all men, including the militia, are capable of bearing arms to preserve the liberty of the state, as it is essential to the whole body of the people to possess arms and be taught how to use them. Moreover, free state, as mentioned in the Constitution in political terms, refers to the nation as a whole. In this case, the security of America. However, it is much more than that. When the colonists took their chances and threw an entire revolutionary war, it was because of the grievances they suffered and the fact that they were too much, and the well-being and safety of their friends, family, community, and society were at risk. Taking up what the framers must have meant by the term free states, it can be concluded that the right to bear arms isn't only restricted to issues when the entire nation is at risk.
So that's a great point. And for the second part of our argument, we claim that the act of publicly carrying arms became constitutionalized in many states during the historical era. So for example, the Massachusetts Declaration of Rights established the right to bear arms during the Revolutionary era. So under Article 17, the Massachusetts Declaration of Rights states that the people have the right to bear and keep arms for the common defense, as it is essential to preserve the rights of every individual, including life, liberty, and the pursuit of happiness.
What weapons exactly does the term arms include, though?
So, Your Honor, Madison, the author of the Second Amendment, refers to arms as offensive or defensive weapons. So, for example, the definition of arms has never restricted the use of military weapons. The legal definition of the term arms includes anything that a man wears for his defense or takes in his hands as a weapon. More specifically, federal law categorizes subgroups of firearms that are permitted under law. For example, machine guns, shotguns, and rifles are considered to be easily portable by civilians. Although missiles and bombs are considered to be destructive devices, they are too heavy to be an item that a man wears for his defense. Referencing United States v. Miller, the court deemed sawed-off shotguns not protected under this amendment, trying to back to our clients, Mr. Nash and Mr. Nosh, and their application of a regular, normal handgun, not any unusual, cruel weapon. By passing this law, the United States Armory and Arsenal at Springfield, Massachusetts, was able to manufacture and distribute firearms during the Revolutionary time periods, leading to better protection for protesters at the time. And then for our next point, we claim that New York's ratification of the Constitution supports the right to bear arms in the modern era. So under Article 2 and Article 4, the New York Civil Rights Law establishes that a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms cannot be infringed. Because of this regulation, there are past instances of the National Rifle Association and New York Association supporting the right to bear arms. More specifically, the National Rifle Association worked with the federal government to support the ownership of state-level permits for concealed weapons when handguns became a necessary factor in the right to bear arms. Therefore, it is reasonable that the New York state law emphasized the need to regulate firearms in order to protect the safety of the public. The framers of the Constitution promoted public safety, a reasonable effort to regulate the usage of firearms. As proved by past historical documents, the court must allow the regulation and ownership of firearms for the safety of the public.
Is there a difference between openly carrying a firearm and concealed carrying a firearm?
Yes, Your Honor. So there is a difference between openly carrying a firearm and concealed carrying a firearm. The difference is in the way the firearms are carried in public. By utilizing an open carry gun, you can openly carry a gun for valid purposes under legal circumstance. Concealed carried firearms are always hidden from the public. The major difference between the two is that owners need a license in order to carry a concealed firearm, whereas some states do not require a license for the ownership of open carry firearms.
How should courts determine if a gun control regulation is controversial, long-standing, is considered long-standing?
Your Honor, laws aligning with the Heller majority have been upheld in some courts as falling into what is called Heller's safe harbor. For laws falling outside of this safe zone, the courts have generally found that a regulation can be long-standing even without a precise founding era analog. This is so because laws that the Supreme Court cited as long-standing in Heller, as laws barring felons and the mentally ill from possessing firearms as things not statutorily prohibited until the mid-20th century.
How should the court consider the public safety implications of licenses to carry firearm?
So, Your Honor, people with a handgun license may be able to take their gun some places where unlicensed people can't. For example, there are different rules for unlicensed carry and licensed carry near schools and at colleges. Also, businesses and other private property owners can usually choose whether to prohibit unlicensed carry open carry by license holders, concealed carry by license holders, or some combination of those options. Allowing the public to be able to get licenses to carry firearms is for the sole purpose of public safety, and the license ensures the capability and acknowledgement of the citizen having a gun too.
So, Your Honor, before we close our side of the arguments, a refresher on the question is, is whether the Second Amendment allows the government to prohibit a law-abiding person from carrying handguns outside the home for self-defense. And we urge the court to recognize that absolutely not. The Second Amendment does wholeheartedly protect the very point of a law-abiding person from being able to carry handguns outside of their home for the exact purpose of self-defense. New York's penal law specifically says New York bans open carry in every form, but a resident may apply to a licensing officer for concealed carry license, which is what Robert Nash and Brendan Koch did. Refreshing your minds, neither men had a criminal history. They were law-abiding men with practice and training in exactly how to handle firearms as well. Precedents, as well as the exact text of the Second Amendment, also proves our point.